My lord, I am not for a moment conceding that this is a good
as a
law.
political party,
It is
as
not
a
a good law.
political party, this is your stance.
My lord, it is not. It is not my stance, and I am not conceding that it is a good law. It is half-baked. It creates more problems than it solves. It's being dressed up as a good law. For example, if your lordship actually decides to turn the autocrat that your lordship just said you were, where is the provision in this act which says that how will the cases be fixed? Section 2 simply says the committee will constitute benches and allocate cases to them. What if your lordship decides that despite that allocation, I am not going to fix any case? I am not saying that the parliament cannot per se make any law as far as the practice and procedure of the Supreme Court is concerned. It can, but that power is heavily circumscribed by various express and structural limitations within the Constitution. So that's heavily circumscribed. But within those limits, it can. And I'll expand on that. The question before the court is, as has come out in discussion recently, is whether Article 191 by itself, and I emphasize upon the word, my lord, by itself, is a source of legislative power. And my submission on that is that it is wrong. And I'll explain the reasons why I say that. Your lordship has already seen the preamble to the preamble itself identifies the source of legislative power that the parliament has invoked. It has invoked two sections, two articles, Article 175(2) and Article 191(2).
नहीं, पर उसी तरह अगर चलें तो 191 में subject to law है, and suppose there is no, and I think there isn't any corresponding entry relating to practice and procedure.
There is no.
So then the word law would become redundant in 191.
No, my lord.
What would happen to that?
That's exactly what I'm saying. I'm trying to proceed step by step. So 191, as I read it, my lord, the mere fact that the expression subject to law is used does not confer any legislative power, just as that it doesn't confer any legislative power under Article 14. What it is, my lord, the power is conferred on the Supreme Court. The power is on the Supreme Court to make rules. Subject to law is a limitation on that. It's a limitation on the power that has been granted to the Supreme Court. Entry 55. Let's read it, my lord. Jurisdiction, and it has two parts. The first part, and my lord, what the Honorable Chief Justice said about entry 59 is exactly my case, and I'll explain why. The first part of entry 55, jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list. So this doesn't apply to the Supreme Court. And to such extent as is expressly authorized by or under the Constitution, the enlargement of the jurisdiction of the Supreme Court and conferring thereon of supplemental powers. Once this is invoked, then, as my lord the Chief Justice said, matters ancillary or incidental or ancillary to any matter can also be brought in. Now, what does this expression mean? Entry 55, there can only be enlargement of jurisdiction, but only where there is an express authorization by or under the Constitution. It is a curtailment of power because the concept of finality that attaches to judgments under Article 184(3)
that's a different concept. For instance, a 3-member bench decides something. Naturally, a 3-member bench cannot undo it. 5-member bench हो गई, whatever, full court हो गया. तो 184(3) की उन्होंने enlarge कर दिया power. ठीक है? I'm trying to wrap my head around the fact that you keep saying that it's taking away the power. The first power was conferred by Parliament through the Constitution. That power is being enlarged. If this power was given to, for instance, the Senate of Pakistan, you will sit in appeal over 184(3) because Supreme Court can't sit in appeal over its own orders. So then maybe, yes, you're absolutely correct. But this power, it has not gone out of this building. It remains within the building. And unless you say 2 minds are always better than 5, that ends the story. So you're saying that more minds would actually be destructive of the 184 inherent power?
Two wrongs don't make a right. If this court was wrong, then then the parliament is wrong now, and two wrongs will not make a right. And
I have a problem with the practice and procedure part. That practice and procedure doesn't really flow out of 55. And that kind of makes the word law then redundant in 191, because that law is not finding any support. Even if we say 191 is not enabling provision, then that law must stand alone, must draw some power from some competence from some source. It's not coming out of 55 because it is purely for enlargement of jurisdiction.
well, it will come if 55 is rightly invoked, then practice and procedure will come in through entry 59. That, my lord, the Chief
No, but
Justice.
59 reads that it has to be read along with the substantive part
Yes.
of it, which is enhancement of jurisdiction. So
Yes.
enhancement of
Let me give
jurisdiction
you-
se related.
my lord, let me give. There are, to my humble knowledge, there used to be one very clear provision, was Zain Wali Constitution dena, regarding enlargement of jurisdiction, and which was actually taken notice of by this court in Baz Muhammad Kakar's case. This was, my lord, before its repeal, this was Article 247, Clause 7. There is a structural limitation on the word law in Article 191. You can't read it. Shoresh Kashmiri's case, PLD 69, Supreme Court 14 said, law is very broad. But here you will not include provincial law. You will, in my humble opinion, you will not include ordinances, because ordinances are executive acts. If you allow, well, if I can just finish this. Well, if you allow ordinances and rules, which are law, to be read into law in Article 191, what happens to 175(3)? Judiciary has to be separate from the executive. How can you allow the executive to make rules for practice and procedure of the Supreme Court? So the law, the word law in 191 has inbuilt limitations. I concede that it will include Act of Parliament, but in certain limited circumstances. Only when entry 55's conditions are met.
So your
Then-
answer to the issue is that you would come through 55, you would come up with a law that relating to enhancement, which is specifically provided, and in that law,
Yes.
you could then ancillary
By
provide
virtue
for
of
practice and
159.
procedure.
That's my reading.
That's the only way to get.
That's the only way you can.
But then those provisions would relate to the enlargement part,
Yes.
not anything more than that.
Not anything. And that's why I say it's a very restricted power. In order to make a law on data protection, which also provides for practice and procedure of the Supreme Court, it has to go through entry 55. So the conditions of entry 55 will have to be met, which may not be possible in this case, because there is nothing in the body of the Constitution, by or under the Constitution, and I'll come back to Justice Mansoor's point on this, just to explain this a little more. There's nothing in the body of the Constitution which allows the Parliament to make this law and to expressly authorizes it to enlarge the jurisdiction of the Supreme Court. Case law is clear that the rules will prevail, but something that my Lord Mr. Justice Naqvi has pointed out, something different happened in practice for some reason, and I'm bringing it to your Lordship's notice. There seems to be no discussion on that. Your Lordship will recall an ex-Prime Minister of Pakistan, Mr. Yusuf Raza Gilani, was tried for contempt and then convicted, and then he was disqualified. Now the trial was conducted by this honorable court. Now the judgments are reported. There was a show cause notice which was challenged in an intra-court appeal. That judgment is also reported. Your Lordship may kindly note the intra-court appeal judgment against the framing of the charge and issuance of show cause notice is reported as PLD 2012 Supreme Court 466, while the trial judgment, the main judgment, is reported as PLD 2012 Supreme Court 553. Now, here it seems that the procedure that their lordships followed was that laid down in the contempt of court ordinance and not the procedure laid down in the Supreme Court rules.
How do you reconcile your proposition with these judgments then?
My lord, I think they are reconciled.
How?
Because this is how. I say that where Parliament enacts a law which Parliament enacts a law on a subject on which the Constitution expressly authorizes the Parliament to enlarge the jurisdiction of the Supreme Court, then Parliament can also prescribe prescribe rules for practice and procedure for that area, for that subject only. The power to regulate the exercise of the power
Does not mean to give a right of appeal.
well, that's how it has been interpreted. Because compare the language, my lord, of 204 with 184.3. Let's read 184.3.
Naturally, they're not identical. They can't be identical. They deal with different scenarios. But the concept of creating an appellate body, that is fundamental.
My lord, the concept has to be subservient to the express language of the
तो
Constitution.
कहाँ लिखा है 2043 में कि अपील लाई करेगी?
My lord, 184.3 में कहाँ लिखा है कि वो subject to law
यार अब
होगा?
आप देखें, आप बहस हमसे ना करें, हम आपसे नहीं सर,
नहीं,
204 देखें ऐसे, this is
आप
not
ये
proper.
कह
No,
रहे
no,
हैं
hang on.
contempt की conviction की तो कोई
204.3
अपील नहीं
में
है ना।
अपील का पावर बता दें कहाँ
My
लिखा
lord,
है?
my submission, and you obviously can
हम
be
समझिए, देखिए आप
The-
गलत समझ रहे हैं, हम समझने की
my,
कोशिश कर
my
रहे हैं.
submission is that the power to regulate the exercise of the power of contempt will include the power to frame a law which allows for trial and creation of an appellate forum. That's my submission.
And this is what exactly has been done in the Practice and Procedure Act as well.
A lot, it is not, with respect, because the power conferred by 184.3, there is nothing in 184.3 which says that that power can be regulated, the exercise of that power can be regulated by law.
Surely you're not equating regulation with substantive right, creation of an appeal. If you are saying yes, they're interchangeable, that's a different argument.
The power to regulate the exercise of a constitutional power has been
Okay, okay, I'll
interpreted.
note it. You're
to-
saying that power to regulate includes power to grant substantive right of
Well,
appeal.
power to yes, that's my submission.
Oh, ठीक है, ठीक है,
And that's
noted.
how- there are two instances where appeals were provided to this honorable court by provincial statutes. In a constitutional dispensation, my lord, the only principle is that the right thing must be done by the right authority. That's the whole concept of jurisdiction. That's the whole concept of competence. The right thing done by the wrong authority means nothing. That's what your lordship said. In province of Punjab versus National Industrial Cooperative Credit Corporation, 2000 SCMR 567, a right of appeal was provided.
Do you say that Parliament is not the right forum to pass a legislation, provide appeal to the aggrieved person?
The Parliament is when it is acting in its capacity to amend the Constitution.
Yes.
Not while enacting ordinary legislation. The Parliament wears two caps. One is that of an ordinary legislature, and one is when it is amending the Constitution.
तो इससे ज्यादा omnipotency क्या हो सकती है? आप पूरे पार्लियामेंट पे तो उंगली उठा सकते हैं, मगर omnipotency of the Chief Justice के मुतालिक आप खामोश.
मैं बिल्कुल खामोश नहीं.
आप ये कह रहे हैं पार्लियामेंट दे सकती है, मगर सिर्फ थोड़ा सा फर्क रह गया है. नहीं सुनिए, सिंपल मेजॉरिटी से नहीं करेगी, वो करेगी 2/3 मेजॉरिटी. बस यही फर्क रह गया ना अब, क्योंकि अमेंडमेंट आ गया ना कॉन्स्टिट्यूशन का, बस इतना फर्क आ गया ना. कर सकती है मगर तरीके कार गलत है.
अगर राइट ऑफ अपील सब्सटैंटिव राइट दी है, तो वो सब्सटैंटिव राइट को कंट्रोल कैसे कर रहा है एक कमिटी ऑफ 3 जजेस व्हिच कैन देन डिसाइड कि कितने साइज बेंच बैठेगा और उस राइट को ब्लॉक कर देगा. So then that substantive right of appeal, which we want people to have, which they have a right to have under this law, that has been blocked. Even in this case, there is a full court sitting. There is no right of appeal now because that right has been totally blocked. So what was the purpose of creating that right? This is a question that I'm waiting for the Attorney General to answer. But just to ask you this question from this side as well, what would you answer to that?
Well, for me, that absolutely highlights the problem with this provision. An administrative power will be used and has been used to completely stultify the exercise of judicial
So the
power.
court can never say कि 10 judges बैठेंगे, 11 बैठेंगे, because वो
Your
appeal
Lordship,
हो ही नहीं सकेगी.
I take it one point further. If the right of appeal has to be provided in every case, right now the sanction strength is 17. That means 9 judges have always to be available to hear an appeal. The largest bench that can be constituted is therefore an 8-member bench.
I think the constitutional amendment has been made by unconstitutional means. शक्ल बदल गई है constitution की.
Quite possible, but this Article 199, your Lordship uses the word law. Law can include ordinances, rules. It will include the previous Supreme Court rules also, because the previous Supreme Court rules were framed in 1956, and they, under Article 268, continue as existing law. So they were also law, and they continued till they were changed and repealed repealed in 1980 by the present rules. So at that point in time, there was no law which actually limited the power of the
Guidance for making rules.
It could be, but as I said, there may be, on my reading of entry 55, there may be some law which can provide for these practices and procedures within very narrow limits, but subject to the overarching constitutional principle that nothing can be done in that law that impinges upon the independence of judiciary. And the Baz Mohammed Kakad case is squarely applicable there. There, the power of the Chief Justice to constitute benches was impinged upon it. It was struck down. Well, an appeal is different because appeal determines rights between the parties themselves. It sort of does away with the concept of res judicata. If there is no appeal, the judgment becomes final, the rights are determined, and res judicata applies. If you take the matter into appeal,
so it means that you are against the right of appeal provided to the general public. You say the Supreme Court can exercise that right, but the general public cannot.
No. I'm not saying that. I'm saying your power, your lordship's power to overrule previous precedent will not disturb the rights of the parties.
You represent a very, it's a political party. Maybe tomorrow it is in majority in the parliament. From your arguments, what I've gathered is that you actually do not repose your confidence in the parliament. What you have said is, as I've understood, that this is a very good law, but in future the parliament may make a law which may have effect on the independence of judiciary. There is no fundamental right that the political party is, argued that is enforcing. They say it's a good law, it should happen, but their apprehensions have been expressed against the parliament. So do you think it's a matter which should have in the first place been taken up under Article 184(3)? Because everyone, and kindly if you can cite any example in any jurisdiction where a good law, a law that actually ensures access to justice, may have been struck down by any court.
Well, Lord, I'll do that. The Indian Supreme Court did that in the Advocate on Records case 2016, volume 1, 2016 volume 1 SCC, volume 5 SCC, page 1. Their National Judicial Appointment Commission had been reconstituted by the 99th Amendment of the Constitution. They put in experts from the public to help and to sort of advise in the process of appointment of judges. That law was struck down by the Indian Supreme Court. A constitutional amendment was struck down because it violated the independence of judiciary, even though, and this is most critical, and I'll...
Learned Counsel,
Learned
Counsel, here in this case, it is actually promoting and advancing the independence of judiciary.
It is not. My lord, I am not for a moment conceding that this is a good
as a
law.
political party,
It is not a good law.
political party, this is your stance.
My lord, it is not my stance, and I am not conceding that it is a good law. It is half-baked. It creates more problems than it solves. It's being dressed up as a good law. For example, if your lordship actually decides to turn the autocrat that your lordship just said you were, where is the provision in this act which says that how will the cases be fixed? Section 2 simply says the committee will constitute benches and allocate cases to them. What if your lordship decides that despite that allocation, I am not going to fix any case?
Constitution में Supreme Court की definition है, उसमें Chief Justice and Judges.
सब जजेस
जो Chief Justice के पास इख्तियारात हैं 191 में कि वो कुछ एडमिनिस्ट्रेटिव काम अपने जजेस को देते हैं, लेकिन अगर यहाँ पे अंडर द लॉ कुछ इनको ये अथॉरिटी मिल जाती है, तो जो कॉन्सेप्ट ऑफ इक्वालिटी है अमंग्स द जजेस अपार्ट फ्रॉम द चीफ जस्टिस, वो कॉम्प्रोमाइज नहीं होगी.
बाज मोहम्मद काकड़ केस में एग्जैक्टली यही हुआ था कि स्टैट्यूट के थ्रू चीफ जस्टिस की कॉन्स्टिट्यूशनल पावर्स को चेंज करने की कोशिश की गई और उन्होंने कहा नहीं हो सकता. मेरी तो सबमिशन ही ये है, मैं बिल्कुल
तो
एक
Chief
मुतलकुल
Justice-
ऐलान
Mr.
चीफ जस्टिस के हक में नहीं हूं.
Mr.
And then my lord, there is a US Supreme Court judgment which is squarely on point. This is Plout versus Spendthrift Farm. This is 131 lawyers edition second 328. This is exactly on point, where judgments of lower courts had become final, appeals had become barred, and much later there was a law which said that all of those cases could be reinstated within a certain period of the promulgation of the act. And the US Supreme Court struck it down as something which impinged on the separation of powers and judicial power.
What about on the point of practice and procedure, and whether the word law gives competence to Parliament, read with entry 58? आपने उस पर नहीं बताया what your thoughts are.
My submission, I'm
Entry
sorry if I
58
missed
के
that.
ऊपर what do you say on entry?
No,
58?
the power to make law on practice and procedure does not confer any power to create an appeal which has been settled, which is a settled law, is a substantive right.
No,
So-
whether Parliament can make law on practice and procedure. That was the question that
Of
has
the
been
Supreme
left
Court.
unattended so far.
No, in my humble opinion, on the subject of practice and procedure per se, Parliament cannot.
Cannot.
Parliament can make laws on other subjects if it is empowered under the body of the Constitution, and then in that limited area, it can provide practice and
So your
procedure.
answer to both questions is that Parliament cannot make law with respect to creating this right of appeal through ordinary legislation. It would be a
Yes.
constitutional amendment, if at all. And secondly, practice and procedure पर भी law नहीं.
जी, पार्लियामेंट जो भी कर सकती है वो कॉन्स्टिट्यूशन की लिमिट्स में रह के कर सकती है. जहां पार्लियामेंट ने खास कॉन्स्टिट्यूशन ने सुप्रीम कोर्ट के बारे में स्पेसिफिक पावर देनी थी वो दे दी. अब ये तो एक पॉलिटिकल डिबेट है कि कॉन्स्टिट्यूशन को अमेंड करके फर्दर उसमें कुछ करें. That can be done, but abhi to we all have to operate within the confines of the Constitution. Every law that is enacted in this country, be it provincial, be it local, be it federal, your lordships have jurisdiction over it. Your lordships are the apex court. A matter relating to company law comes before my lord. A matter relating to property tax in any province comes before my lord. As the apex court, all that laws are laws that your lordships deal with. So it's not that the Supreme Court is being cut out. Here, the problem is that that an external agency is coming in and telling you what to do and how to do. That's the problem. An external agency, and this is what the Indian Supreme Court said.
Let's not denigrate Parliament by calling it external agency. Let's call
External
it
to
by
the Supreme Court. External to the Supreme Court. Only in that sense. एक ट्राइब्यूनल क्रिएट किया गया और उसके ऑर्डर के खिलाफ सुप्रीम कोर्ट को अपील दे दी गई है.
तो अगर हम रहनुमाई कुरान शरीफ से लें, ये कानून भी यही कह रहा है कि आप मुशावरत कर लें अपने जो उल्टे लोग बैठे हुए हैं उनसे. और ये तो हो गया वो वाला पहलू इसका कानून का कि बेंचेस वगैरह की तश्कील कैसे होना है. दूसरे पहलू हैं एक रिव्यू का, उस पर आपने कोई ख़ास बात नहीं की. तीसरा पहलू वो है अपील का, जिस पर आपने काफ़ी कुछ जोर दिया है. एक और पहलू ये है कि अगर अहम आईनी कानूनी नुक्ते हैं तो 5 मेंबर बेंच बन जाए. ठीक है, तो मैं कहूँगा इसमें क्या बुरी बात है. और एक और है कि अगर 184(3) का क्योंकि हक अपील का नहीं दिया है, उन्होंने आर्टिकल 10A का भी जिक्र कर दिया है कि अपील का हक तो अल्लाह ताला भी कंडेम नहीं करेंगे, वो भी पूछेंगे.
आपने जब 1980 में रूल्स बनाए तो सारों ने बैठ के मुशावरत
नहीं,
से
ये
बनाए.
यही बात तो कुरान शरीफ भी कहता है. वो ये नहीं कहता है अगर चीफ जस्टिस में से मुशावरत कर लें. कुरान शरीफ पाबंद करता है कि मुशावरत करिए.
मेरे ख्याल में आइन भी आपको पाबंद करता है. मैं बेहतर समझते की बात नहीं कर रहा. आइन आपको पाबंद करता है. आप इस इदारे के सरबराह हैं, आप पाबंद हैं कि इस इदारे को उस तरह से चलाएं जिस तरह से आप बात कर रहे हैं.
जो बकाया रह जाए वो हम रूल्स में देख लेते हैं. जो काम रह जाए रूल्स में करें.
नहीं सर, आप सारा कुछ रूल्स में ही लिखें सर. मेरी गुजारिश है केसेस की फिक्सेशन का भी लिखे, कॉज लिस्ट का भी लिखे. कॉज लिस्ट सर सैटरडे को इशू है, हमें पता ही नहीं होता. सैटरडे तक ना कोई पर्सनल कमिटमेंट ना कोई प्रोफेशनल. 1 महीना पहले कॉज लिस्ट इशू करें.
कल की लिस्ट इशू हो चुकी है तो किस दिन रखें? परसों कौन सा दिन है? जुमेरात. हाँ, जुमे को रख लें इस केस को.
है ना, अपनी आवाज उठाए ना, मशावरत हमसे करें ना.